Good morning, afternoon, or evening. Here is a Q&A clip in response to someone asking about this question again. So I'm attaching the Q&A clip from a recent live stream session to the public on Q&As, all things Social Security. So take a listen. There might even be some extra tagged onto it of a different video, so you don't have to go searching for it. Thank you so much, and I will talk to you later. Bye-bye. Kevin's going on to say that he's so frustrated with the SSA. They just deny everybody not looking at medical records or just deny you on GP. What is GP? I'm just going to say they don't deny everybody. And this is from the waterfall chart from probably 2 or 3 years ago. Percent when, if I recall it correctly, on initial. And that hadn't really deviated much. And then a smaller amount of those that appeal, which might not be the ones that were denied, because I know I see people who applied, were denied, and never continue on. 15% at that time, the waterfall chart said, were one on appeal at a recon level. So I don't find that to be too terrible, particularly when there are plenty of people who think that they are disabled because they can't do their prior job and they don't want to do other jobs. So they think that's the definition of disabled, and it's not. So I don't think they deny everybody, and certainly not in my experience, but you have to know what you're supposed to be submitting that will make the best evidence for your claim, right, Kevin? And if you don't know that, or if you do know it, but you just aren't going to be able to get it because depending on your age and everything, it is a very, very high standard. Because remember, you have to prove that you are unable to do even the simplest, most unskilled, sedentary, easy, non-thinking, low-stress job in existence. That's a big bar. Okay, physically it's next to nothing, and mentally it's next to nothing. So it's very hard to prove you can't do it. I know the thing that I will say that I disagree with the most about the SSA might be the fact that you might be able to do that kind of stuff. You've got the brains, you've got the physical ability to sit there, but do you have the ability to do it 8 hours a day, 5 days a week? And that's where I think we miss the boat a lot of the time, because it seems like, and I'll blame this on the SSA as much as, anybody presenting evidence. It is easy to show that one can lift 10 pounds or even 15 here and there. It's another thing to come to the conclusion that the person can therefore, because they could do it for that 2 minutes in front of somebody, that they can do it 8 hours a day. Of course, the doctor's records that don't really emphasize how debilitating something is don't help. So, I mean, I really think that's a large part of who needs to be educated. But of course, doctors don't work in the SSD field. And honestly, their job is not necessarily to help people win claims. If you notice, in a personal injury claim, I used to do personal injury work on the defense side, and well, on both sides, but mostly the defense. All the doctors that partake and provide juicy information, they're all paid out the nose by the plaintiff to do that, and by the defendant for the defense side. So they have an incentive. That's why it's with the jury. So there's a lot of theatrics, but they get paid thousands of dollars to come testify at your trial, and they are paid for pre-trial involvement, writing the report, then possibly doing a deposition, potentially interrogatories, but I think it's usually deposition. And you have to either come up with the money to pay them, or you might be out of luck, or your lawyers will do so if they know they've got a excellent liability case and the damages are there. So there's a big difference between doctors treating you who aren't going to get paid to present their record. They don't present them, but they send them in. So it's a huge difference. They're not paid to make up anything or take a side. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Good morning. It just came up in recent conversation, something called the waterfall chart that we see every year. It is put out by the SSA, and it's a nice little graphic, and it explains how many claims are allowed or denied on initial, how many claims were allowed or denied at reconsideration, and then at the ALJ level, how many are allowed, dismissed, or denied. And then it goes on to the appeals council and the federal court, pardon me, this is a little bright, the federal court decisions. So when you appeal it out of the SSA altogether into federal district court. Okay, so I have 2022 here in front of me. I'm going to link this. I'll put it up on the blog, and then you guys can, if you want to look at it. Initial 38% were allowed. That means they were awarded. Now, that does not say whether the date you said you were disabled is the one they chose. They decided it was much later. Less back benefits. That's, of course, possible. 62% were denied. So of the 62% that were denied, that actually appealed to go to reconsideration is how I think that would be. Of those, so it's something less than that 62, because plenty of people drop the ball and don't appeal. So of the ones that went to reconsideration, 15% were allowed, 85% of those were denied. So the 85% then would probably be that rubber stamp we talk about, that reconsideration is a rubber stamp. But if you can see, 15% are not denied. And I'm going to just take a stab at it and assume that the ones that were 15% that were allowed on reconsideration, basically reversing somewhat what the initial denial did, I bet you they got more information in. Maybe they started getting more robust treatment, all the things that I'm always nagging about, and pursued the impairments that they maybe hadn't pursued before. That's just a guess. Could it be that the recon people completely just disagreed, exact same evidence, but disagreed with the initial people? Anything's feasible, but I don't think that's as likely. I just don't. Okay, so of the 85% that were denied on reconsideration, who then appeal for an ALJ hearing, and again, many people do not, the judges allowed, this is 2022 now, okay? So we have like almost a whole another year after that, but that hasn't been, the numbers have not been done because the fiscal year ends September. So I think it takes a while for them to get these out. 51% were awarded. So that's slightly more than half. 39% were denied altogether, and 11% were dismissed. So of the allowance that I said 51%, keep in mind that might be a closed period. It could be a partially favorable, which means, yes, we think you're disabled, but we do not think it went as far back as you said. So I'm finding you disabled as of, X date, not Y date, which would usually mean not as much back benefits as someone would hope. But of course, while everybody wants a nice nest egg of back benefits if they've been waiting a long time, just getting the win is such a great step in the right direction, even if the back benefits are maybe not what you had hoped for, which brings up the fact that you can appeal if you disagree with the onset they found, but there's risks to doing that. I think when people do that, assuming they have won and that's what they're appealing, just the onset, because they want that bigger back benefit, I think you need to tread with caution, and you really have to know what you're doing, and you have to know whether it's a wise idea. So you have to really go through the evidence and figure out why the judge or the decision maker decided it was going to be a later date than you said. Is he or she right that the evidence isn't really clear till then? Because remember, it's not so much what's the reality. If there's no medical record supporting it at a particular time, it often can't become the date. But I have done a handful of appeals of wins that had what we thought was inappropriate onset date. And I have to say, we've always won those appeals. However, I have colleagues I know that it can really come bite you in the butt. I always leave that squarely in the decision-making, of course, of the client. And I explain those risks. The main risk being is the appealing entity could turn right around and say, we don't even think she's disabled at all, not to mention earlier, and then you lose everything. And then you're appealing that if you can. Dismiss, the 11% that are dismissed by the judge. That is generally, I'm thinking sometimes we ask for a dismissal. This is how this works. Sometimes a claimant decides that it is not in their best interest to continue on to hearing. They had a denial at recon, they appealed to an administrative law judge, and they've come to understand perhaps that they don't have strong evidence. It doesn't mean that they're not disabled, but they don't have the evidence that will prove it. Sometimes the punch of getting an administrative law judge denial, as opposed to having left it at the denial of the lower levels of the SSA, that reconsideration denial, sometimes it's better to have that older denial. But a lot of things are going to come into play, like, can the person reapply? If the person can't reapply, then you really can't do this. But so there's a lot of checks and balances that have to take place before you make that decision. But it is not very, very rare for me to think that sometimes you might want to start from scratch because you did a real train wreck so far. And it would be very bizarre if you don't have to get a denial by the judge. And now you have a judge's denial, which you never had before. And those are kind of carved in stone. I mean, you can appeal it to the appeals council and so forth, but I'll go on and explain why that's not always, something you're going to want to do. So we got 11% dismissal, and that would be when you ask to withdraw your request for hearing. And when we do that, we generally give a reason. Sometimes the person has gone back to work. Sometimes the person, doesn't feel that they have a strong case, and they'll express it in kind of like a very general manner, or they haven't been able to, get treatment yet to reduce medical evidence. We ask for a withdrawal of the request for a hearing. And when that's granted, the judge dismisses it. And so the last standing denial was way back on recon, when the person can reapply using perhaps the original date they asserted and start all over. There are some impediments there in terms of the last recon denial might be the one that the SSA is going to hold you to, but there are also places where you can get a reopening of that original application. So it's just like getting a whole new redo. And that's usually when there was evidence missing that the SSA didn't get down below that might have made a difference. Okay, so we know that 51% of the cases that go to administrative law hearing were allowed in 2022, 39% denied, 11% were dismissed. Of the denied ones, which ones went to the appeals council? So people that were denied appealed to the appeals council. We don't know how many that is, but of the cases that went to the appeals council, of which there was over 54,000, is that 1,000? Or is that 1,000? No. It must be 1,000. Remember, they can allow it. That means award you flat out. That's very rare, 1%. They can remand it. That's far more typical. And that's as high as 12%. So we're looking at 13% had a success in terms of AC appeal. They're either remanded or allowed, awarded. Usually it's a remand. And that means you go back to usually the judge that denied you and he gets a redo, because the AC, Appeals Council, is basically saying that the ALJ neglected to do something the ALJ under law had to do before rendering a decision. Okay, so that means 84% at the Appeals Council are denied. So what do you do if you're denied? By the way, 3% were dismissed. I've never sought a dismissal at that stage, so I don't know what that would be from. I'm assuming maybe the person sought a dismissal so that they could now reapply, because once you appeal to Appeals Council, and you have that up there, for the most part, and there are some confusing exceptions, you cannot file again for the same type of benefit while that Appeals Council case is still pending. They considered it double work, and they got rid of it, I want to say at least 10 years ago, a little bit more than 10 years ago. I don't like that they got rid of it. I don't think it's right, but that's the way it is. So when you decide to appeal an ALJ denial to the Appeals Council, you have to make the decision. Am I going to appeal to the Appeals Council and wait for them to decide whether they're going to deny, remand, or allow? And that could be a year. I've seen sooner. I've seen like under 2 months, but I've more often seen it longer. Do I not want to, am I just going to say goodbye to the old case? I still got 3 years of DLI window going on. I'm just going to file again, and this time put more effort into it. Or get a lawyer. So that is a reason why some people will not appeal to the Appeals Council, because they want to, boom, go out the gate again, super strong, and try again. If you are denied, that 84% that are denied at the Appeals Council, they go on to, if they choose to, it looks like there's 21,000, I think. I can't really figure out what this says. Federal court. So if you're going to get a lawyer to do that, is the lawyers that do federal district court appeals for SSA are generally very good at what they do, and they know how to find appealable issues and find when there is not an appealable issue, and they're not going to take your case generally unless they see a pretty good one there. But that's because they're working for free for you. They need to keep the lights on also. So they're going to be very stringent, I think. But as it turns out, for those that do get appealed up there, 1% are allowed. That means awarded. So again, the federal district court doesn't generally make the decision of whether you're disabled. It usually remands. And in this case, 58% of cases sent up to the federal district court, that's more than half, are sent back to the judge for a redo. Or I think it actually goes to the Appeals Council. Usually remand it back to the judge. That's pretty nice. Federal district court, if someone's going to take your case there, you've got a decent chance of prevailing. 37% were denied. That's not fun. And then once the person is denied, I should say too, when you appeal to the federal district court, unlike when you appeal to the appeals council, you can file a new claim if you are insured still, or maybe now you're poor and you could file for SSI again, or what have you. There is no bar to having a federal district court appeal going on while you're filing a whole new claim on a whole new period. That is different from what I said about appeals council, where you can't do that. By and large, there's some exceptions. So there you have it. I mean, your little flow chart here. And again, I'm going to pop it up. It's not going to get up there today. Hopefully by the time you see this, I will have this up and linked. It'll be linked in the comments below. Yeah, so initial, 38% allowed. Reconsideration, 15% allowed. Oh, going back to it, I did a recent video on the benefits of reconsideration stage because it's a controversial thing. I am a fan, and I'm looking at it right here. 15% of the people were awarded and did not have to go onto that lengthy, stressful ALJ hearing process. Nor did they have to go on to appeals council or federal district court. They won. Is 15% 80%? Of course not. But it's 15%. 15 out of every 100 people that did it are glad they did. But the bigger point I was also making in that video, maybe I'll try to link it, is that even if you don't win on reconsideration, assuming you now have your ducks in a row that you might not have had on initial, that time is helping your evidence grow if you're doing what you're supposed to be doing. So if you're listening to your lawyer and you're following directions and you're really, being a good student of this, and making your case your primary job, that reconsideration stage, I think, goes a long way to the administrative law judge award rate of 51%. So, these folks who have reconsideration, now everybody does since like 2019 or 2020, when they put those other 10 states back into reconsideration, I think it gives people more of an opportunity to prove their case, because now they have all this extra evidence that they were able to get that time-wise they would not have been able to get if they went right from initial denial to ALJ. They missed all this time period it's like practice. Like when you join a sport, you need time to practice, build, blah, blah, blah. You need to build that evidence, get that treatment that will prove what you're saying all along, right? That's my opinion, that the reconsideration period can be very useful, even if you're not one of the 15%. I think it makes it more likely you're going to be one of the 51% of the ALJ later on awards, versus, if you sit on your laurels or sit and do nothing during recon, you're not helping your case any, and you might be in that 39%, or more likely to be in that 39% denial. But anyway, for the rest of them. But anyway, fascinating. We have a 2021 chart too, but maybe I'll post them both up, but I'm not going to do a video on that yet. All right. Ciao, guys. Bye. Thank you for joining and taking a listen to this video. If you have any questions that relate to this or anything else with regard to Social Security, disability, retirement, SSI, etc., please do feel free to post it in the comments below, even if it's not necessarily related to this video. And I will see them. And if it's something I can do a video on, I will be happy to do that. If you are looking for representation in a current battle to prove that you are disabled, whether you have applied yet or not, and ideally, if you have not applied yet, that's when we like to come in and start from the beginning and do our wonders. You can go to joydisability.com, look up to your left, and there's a little link for a free SSD evaluation, and we will take a look at it and let you know one way or the other. If you are looking for a consultation, not representation, or you can't get representation for whatever reason, or it's a non-representational type of issue you need to review, you are more than welcome to order a prepaid consultation. It will be with me personally, and that link is on that same page, joydisability.com, but over on the upper right. Anyway, thanks for staying tuned, and I hope to see you every day, 9 a.m. with our little video shares or live Q&A if you want to join me live on Wednesdays at 1 p.m. Eastern Standard. Thank you so much. Have a great day. Bye-bye.